Good evening, everyone, and welcome to the May 8th work session of the Ann Arbor City Council. Today we are going to discuss the Michigan medical marijuana regulation environment and a legislative update. I believe we are left to the tender mercies of Mr. Postema.
Council, I'm happy to be here tonight. I already have done a dry run of this for the Michigan Municipal League. 100 or so council members and mayors from other cities across the state in March, and they were very interested. I think they invited me to come in part because I've been part of this discussion really since 2004 when the city first did a charter amendment on compassionate care. Obviously, that was 4 years before the state did this, but I mention that because Ann Arbor has often been ahead of either state or federal legislation. Some people are pleased with that. Some people are unhappy with that at times. But that is the nature of local government. I've given you an outline, and I have a public outline with the materials. I put that up for the public. It's a little small, but this is a shortened version of it tonight. I did want to go back and give some context to why we're here. I'm not going to start at 2900 BC on the medical history other than to note there's a long history of, and I've entitled this really from medicine to criminalization to state regulation, and that's what we're talking about tonight, the 2016 regulation. But I want to look at it in terms of the last century where after a long period of non-criminalization, marijuana was one of many substances that became criminalized in the beginning of the 20th century, both state and federal bans. The legislative reform effort really started with criminal law, and that is a medical defense to the use of marijuana that was recognized in criminal law before many legislative efforts took place. Obviously now we're up to 28 states in the United States, plus District of Columbia, have medical marijuana laws. Michigan was the 13th state to do this in 2008. And this trend really reflects the national poll now that 93% of adults, people over 18, favor medical marijuana legalization. That's as of February 23, 2017. This is done within the broader context of marijuana legalization efforts. Obviously, our state is in the throes of that too. There's a new initiative that may be on the 2018 ballot. But again, 8 states have decriminalized recreational use of marijuana, and part of that really has been the cost of mass incarceration. That really is one issue that has been out there. And again, the polls on this, 57% of adults favor legalization of recreational marijuana, and that's again as of February of 2017. But we're really here to talk about medical marijuana because that's the law that was passed by the voters in 2018. And at that time, as you know, the legislation that was passed talked about caregivers and patients and did it in a way that was small scale. That is, small scale caregivers growing the material, having up to 5 patients, and that was really the model that we had. Now, after 2008, the confusion for the state law was, well, how do you work in dispensaries under this type of a scenario? And a lot of people who looked at the law said the 2008 law does not cover any larger scale dispensaries other than a caregiver with 5 patients up to 60 plants. There was a lot of debate about that. It took actually 5 years for that debate to be settled. But to say that it was confusing, you all, and I'm looking around the room right now as to the city's ordinances, I believe only the mayor was here during the time period when ordinances were adopted, and there was a discussion that all I can say took up a lot of the council's time on drafting things at the council meeting. Again, you're always free to do that, but I think it's safe to say it took a lot of council time. And it took a lot of council time because the law, and again, before I say this, the law was difficult to interpret in one sense because it was written not by the state legislature, although we've seen in many times when the state legislature does not draft laws that are comprehensible. But in any case, this was a citizens' initiative that went on the ballot. And so in that sense, it wasn't drafted perfectly, and it caused that confusion. And when I say not perfectly, an ordinarily moderate judge on the Court of Appeals, when first looking at this law, you might remember this, when they took a look at this law, said, I again issue a stern warning to all. Please do not attempt to interpret this act on your own. Reading this act, that is the 2008 Act, is similar to participating in the Triwizard Tournament described in Harry Potter and the Goblet of Fire. The maze that is this statute is so complex that the final result will only be known once the Supreme Court has had an opportunity to review it. That was People versus Redden in 2010. Well, in 2013, the Supreme Court did interpret it and said, really for the most part, it did not allow a dispensary-type patient-to-patient transfer and a business model. And so likely there is no viable business model for dispensary that would be protected, although some people may still dispute that. There were also serious inefficiencies in the patient-caregiver delivery system, although for some people, patients and caregivers, it did work. So that leads us up to now. The legislation that we're talking about now is the Medical Marijuana Licensing Facilities Act. It was passed in September of 2016 and was effective December 2016. Now, this act, while it was passed then, the effective date, and why we're bringing this to you now, the effective date, they're not even going to take business licenses, and I'll talk about the overview, but the time period to do this for the state is not really until December of this year. That's the time frame. And what's interesting about it, I'll just give you the overview, is that it allows 5 different types of facilities. It provides for a very extensive medical marijuana licensing board and licensing enforcement ability. It has seed-to-sale tracking process, and it provides significantly for a tax and fee structure on facilities. And just to get the scope of this, when I gave this presentation in March, Shelley Edgerton, the director of the Licensing and Regulation Bureau, came and spoke with me. And there are a lot of unresolved issues on that. We'll talk about that in a minute. But the magnitude of this, they're contemplating hiring up to 160 people at the state, 160 FTEs. They're talking about $40 million additional cost to set up this regulatory structure. And that is, again, why I've entitled this, again, from home remedy to criminalization, now to a state-regulated industry. And I'll talk at the end of this how this fits in with the federal legality, because this is all an illegal substance under federal law, and we'll talk about how this fits in. But again, the issues about the power of local law, the power of state law, and the power of federal law, this is another instance where the city is where the rubber meets the road, and this is where decisions are going to have to be made and are allowed to be made under this act. Again, when I get back to this, the overall decision that a city is going to have to do is decide whether they want to opt into this legislation. If you do nothing, if you decide that you're not interested in any of these type of 5 facilities being in the city, then they're not going to be in the city. You have to affirmatively do something. Again, so that is what you will be called upon to decide come the fall or at a later time period. And so there's nothing that you need to decide tonight. It's a work session, so you don't decide anyways. And it's not going to happen this summer. But when I talked to the city administrator and we talked to the admin committee, we thought this would be a useful presentation to have right now to get ready for the type of decisions that you're going to have to decide. And frankly, you might start hearing from people who want you to do one thing or another. First of all, the five types of facilities and their limitations. Each of the 5 types are a commercial entity. Grower, there's 3 types. And again, these types of facilities, there are restrictions as to co-ownership of one type of facility and another type. And it will make sense, for example, a grower, another type is a safety compliance facility. You don't want the same owner having an ownership of a safety compliance facility and a growing facility. So again, grower, there's A, B, and C growers. A processor is a second type, purchases from the grower and makes or creates marijuana-infused products. A secure transporter, this is like a Brinks truck for storing and transporting between facilities. Provisioning center, it's most analogous to what people think of as a dispensary, a place where people can go to purchase from a grower or a processor to make a product available to qualified patients who are all already qualified under the Michigan Medical Marijuana Act. Finally, the safety compliance facility receives the marijuana from another facility or a primary caregiver for testing. Now, this has proved in other states to be very big business. In fact, when I spoke in March, there were council members, there were mayors, there were city administrators, and there were also a lot of businesses who were there handing out cards for facilities. And if you look at medical marijuana law, just you type that in for MLive for the state, they are going to all sorts of cities that are in the newspaper about what they're going to do with their industrial base. And this is significant economic activity. Now, those are the 5 types. The broad authority of the licensing board is certainly established, and it is the state that is going to license all of these facilities. So, and how this is going to work with the local government, if you decide to have them, because there will be a permitting process. I don't want to say licensing in the same way, but that's one of the issues we're going to have to figure out, and everybody's trying to figure out with the state. Is there going to be contingent approval by the city until the state board has approved these things? So that's something that we're going to need to work out. And Lara has significant regulatory responsibilities. I've listed some of those in the paper. They're going to be doing the licensing, the background check, the pre-licensure compliance, collection of fees, complaint investigation, all of the administrative hearings, and they're supposedly going to do this with up to 150 people and $40 million. So how they're going to do it and how they're going to start doing it, the city administrator has also heard the presentation from the director of Lara, and it is quite a task that she will readily tell you at any group that she's speaking to is going to be quite an effort for the state. The one obligation that we do have when we get this all set up, when there's notification that a business has applied for a license, there are obligations of a municipality to provide certain information about what their ordinance is, what their zoning is, whether they allow it. And the timing of these things really has yet to be determined. The issues, again, for the city to decide will be, are you going to pass an ordinance to allow one or more types of these facilities? Just because you have one facility does not mean you have to have other facilities. Now, some of them, it seems to me, would not make sense to have only one. For example, how you would have a facility without a transport facility that was permitted. That would be a very awkward thing, because how would you transport it around? So, you know, we'll certainly, the council will certainly need to think through that. When you look at zoning or when you look at permitting or other things, while you do not have to have all of these types, you know, you'll have to think through that. Some of them, by state law, for example, growers can only be in areas zoned industrial, agricultural, or unzoned. That's already set by state law. So I think the concern there obviously was they didn't want to give options to have grow facilities in areas where they wouldn't be allowed in a city. So now the way to, the other consideration that you'll have to decide is, are you going to allow this? And if so, are you going to zone it, which we already have, and I'll talk about our present statute. Are you going to, how are you going to zone this? And then are you going to limit it in any way? Because if you have the ability to not allow any of these facilities, you also have the corresponding ability to limit the number. That is one thing that you could do through a permitting process. And again, that's something that I think the committee that you set up is going to give some advice on that, but certainly there are zoning things that you can do, and there are other regulatory things that you can do. How this is going to work with whether the state approves it first and then it comes back to the city on permitting, that's something, frankly, we need to work out and we'll need to work out with the state. We have a good relationship with the director of LARA. We have contact with her in Councilmember in liquor. You know, Mary Fales has a good relationship, and you know, they're really looking at these things. So she's asking for help from municipalities, and we've already provided some input to her. Some of the things that we'll look at about in zoning will be certain federal laws that prohibit drugs within 1,000 feet of a school, playground, or public housing. So that's something that's going to need to be looked at. The other thing is, with a city permit, fees can be charged for each of these type of facilities up to $5,000. And so when you multiply that by significant business, that is going to be a fee structure if you decide to have these, and it's a revenue structure. The other thing is, there is also a revenue stream associated with this, and it's the calculations will be set up. It's I think 3%. How it's calculated, they'll be looking at this, but the permit fees and the fee structure will be set by state law. Other local regulations that are unclear, hours of operation, days, signage, those things are things that are going to come up. LARA has broad authority in its regulations, and again, we're going to have to figure out in working with the state how this relationship, if you decide to go this route, how it's going to work out. Now, the biggest issue to talk about is that, again, I mentioned before, local law, state law, and federal law. Marijuana is illegal under federal law, and it's still as recently the DEA has denied a petition to reschedule the marijuana. 2005, they held that Congress has the constitutional authority to prohibit the local cultivation and use of marijuana, despite any state law to the contrary. Nevertheless, what has happened is that under the prior administration, and that's still continuing today, the federal government has said that it will not pursue actions against marijuana businesses and users who comply with the state regulatory scheme. And that's very important, and why the 2016 law is important in one sense for businesses in the state of Michigan, because without that sort of safe harbor from the federal government, they would be at great risk. In other words, their priorities for the federal government are if they're complying with the state regulatory scheme. Just as an aside, that's an interesting situation to be in when they have the authority and yet are not exercising it, are not enforcing, and saying, well, we're not going to do anything, in fact, if there's a state scheme. So It's fascinating to watch the interplay. The current administration, however, has been inconsistent in their statements about on marijuana. There does not seem to be an indication that there will be a change towards enforcement of medical marijuana. And interestingly, Congress, the Republican Congress, has banned through budgetary restrictions, and I'm waiting to see this week again, they've banned the Department of Justice from federal enforcement actions against states that implement a medical marijuana regulatory framework. So through the power of the purse, they have directed something that they have refused to just make, they could just change the law and reschedule it. So do I think that, again, I deal in law rather than reading tea leaves. Do I think there will be federal intervention in state medical marijuana laws now that 28 states and growing have this? That would be a tremendous effort by the federal government suddenly to use its enforcement power against most of the states, a majority of the states in the United States. So I think it's unlikely, but again, that's neither here nor there. The federal government could change its mind and could do whatever they wanted to on this issue. Now, when I spoke at the MML conference, the issue really was, why would a city consider opting into a state regulatory network despite federal law? And really, it's a policy choice, I think, that access to properly processed medical marijuana for its residents, when state law allows it, when the federal government has given sort of a safe harbor to do this, that's a policy issue for you. And it's a policy issue that in some ways you've answered before, although when you answered it before, there was only one of you answering it. And the city did draft an ordinance and did draft zoning, and all of that will need to be changed to accommodate the new law. And so there are things in that. The fact is they had a licensing scheme. Kristen Larkham, who's here with me, worked on that. But we've never licensed any business in the city of Ann Arbor, partly because of the odd state of the law, and then ultimately when the Supreme Court ruled, we didn't license. So we're really going to have to start over now, and the state has said everybody needs to start over, and in starting over, they've sort of given a timeline, and again, they've talked about how much it's going to take to do this at the state level, but that really is the issue that will come before you probably in the fall. The other thing is, in addition to the policy choice, for a lot of states and cities that have done this, for their residents, they don't want to have their residents travel to other jurisdictions to obtain that, and that's a policy choice. And I think even cities that attended in March that you wouldn't have suspected were interested in this are going to look at this very carefully, because they realize that the law has changed. In fact, I was actively involved in the change of the law in giving testimony before the Judiciary Committee and other things about the practical effects. Not the policy. I'm not a scientist. I can't weigh in on this, but the practical effect of the enforcement mechanism, and the fact that, again, no discredit to the people who put the Citizens Initiative, but as a mechanism for dispensaries and other entities, it was, as the judge said, it was sort of a mess of legislation. And so the 2016 is cleaning up that issue and making it clear how the law should apply to facilities. And when I say a mess, what I mean is I don't think it ever was intended to address dispensaries and large-scale operations. And so the 2016 law really fills in that gap. So other states with a comprehensive medical marijuana regulatory scheme have extensive taxation, and the state of Colorado, for example, $1.1 billion to the state in 2016. The other issue that will come up again is economic development of significant range of commercial business, including safety compliance facilities. And actually, the first time I discussed with the new city administrator then in August, his view was in setting together what are big issues facing the city, he saw immediately that this is going to be a big issue, and that was before the law was passed in 2016. But I think he was correct about that, and I think that when people are already calling and I'm getting emails about what's happening, what is the structure going to be. Finally, and I'll leave it at this, I think that some of the council members have asked me before about the initiative in 2018. And conceptually, medical marijuana is different than recreational. But I think that the state is doing this because this type of state licensing scheme is really likely, in my mind, to be the template for when recreational marijuana use is legalized by federal or state law in the future. And again, I believe that it will be in the future. When the 2004 charter amendment came up, people asked me, how long is it going to take until dispensaries are fully allowed under state law? I said 15 years. Well, I was off. It's 13. And people have asked me again, how long is legalization going to take? I think it will be 5 years, less than 5 years in the state of Michigan. Whether it goes through in 2018, I can't really predict. But I think that that's why it's important, and some cities that ordinarily wouldn't have been interested in it are seeing the future and trying to get a regulatory scheme in place at the local level for when that comes. And so, again, I don't know what that would look like. We don't have to anticipate what that would look like. But I think that we do have several issues that will come back before you. And I said I could do this under a half an hour, and it's 29 minutes. So I've kept my promise on that. But I think that that gives you an overview of what's coming. And if I wanted Mr. Delacourt to come up because he does have, we have some things that are going to the committee. And again, coming in this summer, and when this law was passed, right away, I appreciate Mr. Delacourt coming in and wanting to jump on this right away, because he, again, saw there's going to be a lot of work to do on it, and he is working with the committee, and I'll have him update you on some of the efforts that are going on.
Sure, I'd be glad to. As Mr. Postma said, we've started to work with the committee that was appointed by council several months ago to evaluate the current licensing or permitting ordinances and then make suggestions to staff to bring forward to city council. Council asked that work be completed and some kind of report out, hopefully be done by June 30th. I do think we are on schedule for that, working with Ms. Larkham. We've provided a draft permitting ordinance. We're now referring to permitting because the state's obviously responsible for licensing now. So a permitting ordinance update that deals with and updates our ordinances based on what Mr. Postma just said about the 5 license types. That is actually going to the committee for review for their first comment this Thursday morning. So the committee is going to meet, review that ordinance, comment back to us as staff, point out what they do, they don't like, ask for changes. We don't know if there'll be material. We have met twice in the past, discussed what the committee thought was important, what their view of the new legislation was, and how that should impact our permitting ordinance. So that'll go for their review this Thursday morning. If there aren't significant changes, we expect to make any adjustments, take that back to them late May, early June, have them comment on it. Hopefully it's in a form or a state where they're comfortable with it and can make some recommendations to you guys as council, and then we'll forward that on to your review. The second part of what we're doing is based on that draft ordinance. We've now engaged and started the zoning process with the Planning Commission. Staff has come up with some ideas as to how we will handle these 5 license types, what's good in the current zoning ordinance, what potentially may change, and plan on taking those recommendations for consideration to the Planning Commission in early to mid-June, and we'll start that conversation with them. They ultimately will make any recommendations to council on changes to the zoning ordinance. So we expect these things to run concurrently. As discussed earlier, the state's not even going to begin its accept license applications until mid-December. So we feel we are on schedule, and we'll be having the appropriate information in front of you guys soon.
Thank you so
And
much.
I'm obviously here to answer any questions.
Any questions?
Questions from council? Councilmember Grand.
Thank you. How is public housing defined currently?
I will have to, you mean under the federal regulation?
Yes.
I will have to get the exact site. I will get that from Mr. McDonald and get that out because that
Thank
is
you,
going
just so I
to be.
can take that back to Housing Commission. Thank you.
Okay.
Awesome. Thanks.
Councilmember Lum.
Thank you. So, thank you both for all your work on this, to bring us to where we are at now and to tee things up on time for the changes that are going to happen at the state level. When we, and I wasn't around, we're looking at revising the ordinance previously. We didn't end up making any changes, I guess, right? And so you've now worked on a permitting ordinance update. Were there other issues we were trying to address at the time, and do those issues still exist, or is that all changed with the?
Well, the current licensing ordinance that we have is obsolete now. It
Okay.
just wouldn't, it has no effect. People, entities were never licensed. And so, in that sense, we're looking at a rewrite. I think at the time, if I understand your question, I think the concerns at the time, given that the state of the law was uncertain between 2008 and 2013, the concern when they first put it in was whether or not they should have a limitation in the number. And that came out of a concern from a study out of California where they initially legalized to a certain extent, and there was an influx, and they were concerned about a mass of facilities all in one location that caused problems in those locations. That is either crime, depression of value to property values and so on. So there were concerns at that time. And I think generally, although I can't speak for the council, I think that there was a concern that since this was really a test case, and it wasn't even clear under the law which way the law was going under state law, that it was wiser in theory to have a numbers limitation rather than, and they did have zoning issues, but there are other things you can do with zoning about distances and other things. So I think that was sort of the current concern at the time, but it was a concern that was rooted in, I believe, and the mayor was here, I think it was rooted in the concern about the legality of the entire state law. And so, you know, I think that with the explicit permission under the state law now, 5 types of facilities and so on, that's something that the planning commission will look at, and then the committee will make a recommendation. So as to what concerns you all will have, I think it's a different era, and there's more data out there about this.
Okay, thank you very much. So in terms of these 5 types of commercial facilities, I can understand, and this is going to go to the Planning Commission for their consideration first and recommendations ultimately to council. I can understand the benefits to residents in allowing provisioning centers, but the benefits of allowing some of the other types of facilities, for growers, processors, transporters, and so on, that's not as clear to me, and I'm just wondering if there are benefits to Ann Arbor, just besides the revenue that could be collected.
Again, we'd have to look at that. I think that's part of what's going to come back with the committee. because each of these things have their own purpose. How they're going to fit in, again, I know that there are safety compliance entities in the state. We'll take a look at those. We'll get more information on those. They're not operating in the same way, but we know they are operating. And so part of that really will be, we'll have additional feedback, I think, from other states. And certainly Colorado is one that has great experience with this, and we're in touch with people there.
Yeah, I can add, the committee's had some discussion on the 5 different types, and the one that's probably newest and hasn't been discussed at length is the processing. They've looked at least the committee and staff has looked at both the secure transport and the laboratory or the testing facilities, similar to other facilities we already have in the city. We have, as Mr. Post referred to, we have Brinks trucks all over the place that operate in a secure, licensed, bonded manner. And we see the transport being very similar to that use. Maybe even some of the same companies will get into doing that as licensed facilities. So from a land use standpoint, we haven't seen that to be much different than some of the existing land uses we have. Same with some of the testing laboratories. We have laboratories that test different materials from food to hazardous materials and things based on state licensing within the community and all over Southeast Michigan now. We can envision a situation where existing laboratories get in the business of doing this testing, or new facilities come up that are very similar to that are controlled by these state licensing provisions. But from a land use, similar to other uses we have now, as was discussed, the provisioning centers are similar to what we've dealt with in the past as far as dispensaries or transfer facilities, depending on what you want to call them. And then the grow operations are obviously ones that are going to have to be discussed, and already the state dictated where and in what types of zoning districts those can go in. So that'll be more of a discussion if we want them, not where we want them.
And again, they may be in other places that they're looking at. They're going to a lot of townships. There's a lot of land. There's other agricultural land. So it may be that as far as that issue, whether the city has that space for it here or how that operation would go, I don't have a sense of that because, as you know, I usually stick with the law.
Okay, thank you. You really have been studying this in depth, clearly. Do we have a sense of what other communities are doing in terms of these commercial facilities or have already done in allowing these commercial facilities?
They're up and running, but we have not looked at it fully, but that discussion is going on amongst city attorneys, amongst other municipal groups, and so that information will be coming out.
And does the county have any role in this, or is it just the municipalities?
I believe it's defined as municipality, and I take that more as a city and township, but that's something that I would have to look into, and I'll advise you further on.
Okay, thank you.
Councilmember Ackerman.
Thank you. I think this is something we're all going to have to react to, so I appreciate you all being proactive in that reaction. In terms of the cost of regulation, the 40 million and the 160 FTEs at the state level, I think like to liquor licensing and how we've ceded a lot of that regulation to the state government, but there's still significant costs to the city attorney's office, to the police department, and to the treasury office. Do we have a sense of anticipated cost per permit? And is that something that you could come back to us with as we're deciding our fee schedule? And is 5,000 capped by the state legislation?
Yeah, up to 5,000 is what it is, although that's for each type of facility.
Understood.
And even within the grow facilities, I believe that if they had, the small, medium, and large facilities, I think it's a separate permit for each, even if it had more than that. And so, again, when you look at fees, that $5,000, I think, may be pretty accurate. I think they didn't skimp on the cap.
Understood.
Yeah.
Understood. I think maybe some more information just on, projections of what costs may be, would be helpful as we determine those details. I also, in the same.
You mean on cost in terms of time within the city.
Staff
to
time,
do
thank you,
things.
yeah.
And again, we will give that as sort of at a real time as things move, because while we work with the state on who's going to be doing what, how it will be set up, that's something that Mr. Delacorte is quite accurate about his staff, but it sort of depends on what the state says. And so you'll be getting that information as we understand it over time.
I can appreciate that. And just given the kind of fluidity of how, again, we have ceded a lot of responsibility to the state around liquor licenses, I imagine that dynamic may change. Yeah, fair enough. Yeah, we didn't cede it, they took it.
They took it. Yeah, they
But
took it.
I'm trying to be diplomatic. And so also in that same section, the Roman numeral 5C2, limit number of permits for each facility, is that getting at, I mean, would you limit the ability to vertically integrate? So let's say in a manufacturing district, if we were to permit grow operations, and you limit the number of permits per facility to one, you wouldn't also be able to do distribution?
Well,
Because you can, because according to the zoning ordinance now, in the M1 and M2 districts, you can, under the category of type sale, you can have medical marijuana dispensaries. So if permits were limited by facility to one, you wouldn't be able to do both grow and distribution?
that would be correct, although again, the present both zoning and licensing, certainly the licensing is obsolete. The zoning did not contemplate 5 different types. It sort of lumped it. It was
No.
looking more at dispensaries.
Sure.
And
I
so-
guess I'm jumping to the M1 and M2 districts just because if you were to allow growing in the city, I imagine that's where the appropriate place would be without, without any knowledge of what the community is discussing. That was just a first assumption, and I was using it as an example, just that, say all 5 uses were permitted in M1 and M2 districts. If you limit the number of permits per facility, you do limit the ability for firms to, I guess, vertically integrate for, would that be a correct assessment?
Well, if you're talking about vertically integrating in terms of an ownership structure,
Sure.
there
Well,
are
and on a specific location.
firms with the ownership, there are limitations on cross-ownership. And so
Okay.
that's why I'm getting stuck on it. There's already, for example, a provisioning center may not have an interest in a secure transport or a safety compliance facility. So those 2 facilities,
No,
for
yeah,
example,
right.
could not be. Going to growers, they can't have, again, the safety compliance.
But they could distribute. They could process and distribute. So you could have all 3 of those uses in the same
Yes,
district.
yes, I believe so for grower and processor. The only one that seems to have no co-ownership, secure transporters have to be independent of all 4 of the other facilities.
Okay.
So,
I'm going to take that as a yes.
yes,
All
it
right.
depends. I'll have to look at the zoning
Okay,
again.
thanks.
Yeah.
I'm good, thank you.
Councilmember Warpahowski.
Right.
you. Mayor
Right.
Taylor,
That really is a zoning issue. That's what Mr. Delacorte is saying, yeah.
This is just on zoning issues, just a quick question. You mentioned how the grow licenses are restricted by the state or statute on what zoning classifications they're allowed
Yes.
for. Is that the only piece that comes from the state to limit uses? For example, the processing or the safety compliance centers, does the state give us any restrictions on where
No.
those? Okay.
No, and that's why specifically, they were very specific about the industrial, agricultural, or unzoned for the grow facilities, because those have been, as people looked at grow facilities in an unregulated state, those are places that have caused difficulties as far as, they could be very large, water usage, light usage, hazards that they were looking at. So I think that
Okay.
is likely why it's contained like that.
Thank you.
Councilmember Eaton.
Thank you. So does the state statute tell us what our local ordinance must have at a minimum?
It really goes through what they're going to do, and what it says, that, and what it talks about is an obligation in 90 days, whether they're set up at, or not after December, that we have to let them know when somebody applies, well, do you have an ordinance that allows this? Do you have zoning that allows this? And then are they permitted? So within the requirements, that is something that frankly, in discussions with Director Edgerton, has been a concern. That is, what's left for the cities to actually regulate. Because if you look at what they have scoped out for themselves, it sure looks fairly all-encompassing when you put it down on paper, and she had her presentation. And so what's left for the cities is
That kind
not
of
clear.
goes to the maximum that we can do, but is there a minimum that we have to do in order to permit? I mean, it's only permitted if we have an ordinance that permits it. What does that ordinance at a minimum have to say, just that we permit it?
That's the problem, it doesn't say anything. And so, again, she's very upfront about this. I think if she were here, she would say the same thing, that the minimum is not there, what we need to have, other than we need to permit it and how we're going to permit it. So you can see there are going to be a lot of issues, again, even the issue of, well, if you don't have to have it at all, could you limit by number theoretically? I believe you probably could, but that's certainly an issue that the state hasn't weighed in on in that sense.
And you mentioned that one of the things we may want to do is limit the number of facilities allowable, or even which kind of facilities we want.
I've not said that we should do that. That's something that I think the committee that you're looking at is, again, if you are looking at local regulation, that's one thing that is theoretically available to look at. That is, do you have an unlimited number, or do you have, everybody who gets a permit by the state and is in the correct zoning designation has a right to go forward. So that,
And so I have concerns at both ends of that spectrum. If we limit it too much, what we're doing is creating almost a monopoly. And if we don't limit it enough, then we just have one in every neighborhood. So I would certainly hope that with certain kinds of facilities, we would limit how close they could be together.
that's a standard regulation by zoning that's been allowed for all sorts of things.
But on the other hand, not have those limitations on distance apply between the different kinds. Because it doesn't matter if the secure transporter is next door to the grower, as much as it matters that growers are occupying the whole neighborhood.
And again, I'm nodding in some ways, but really it's Mr. Delacorte in guiding through.
Oh, he sat down, so I can't.
Well,
I took my opportunity.
ultimately, he will provide some direction, but those are going to come back to you through any type of ordinance that we have if you go in that direction, both the zoning and the other things. So your comments right now, I think, are helpful to take back to the committee that's going to be providing advice, but ultimately, you're going to be making that decision. So I hear that concern.
Yeah, and I think it's safe to say that's been central to a lot of the discussion the committee's had. Committee has talked about number of licenses. They recognize that the Planning Commission deals more with distance regulations, which you mentioned, and how to jive those two conversations or bring them into one cohesive kind of recommendation to council. We understand that both of those may be a part of that.
Especially the proximity to the.
Understand?
Do we know how many dispensary-type operations we have in Ann Arbor right now,
Well,
approximately? I know they're not permitted and they're not licensed.
there are people operated as a dispensary. I would safe to say that there are more than 10. In one sense, obviously, if you do not opt into this, they will eventually cease. The issue of making a change right now prior to this law going into effect, I think is sort of prosecutorial discretion in one sense, and I think that that is not necessarily a wise thing, but.
Well, my concern about the number that currently exists is, I wanted to know if there are a number sufficient that we can ask our law enforcement whether those operations create a burden on law enforcement, and whether we anticipate that an expanded legal scheme would create a burden on our law enforcement.
In fact, that's an excellent point. It actually relates to something that as far as the data point, the concern that took place in the discussions in 2010 and 2011. And I think that the police do have information on that. But the ones that began to operate during this period, the ones that had difficulties, we helped shut those down. And so we do have some sense about the operation of other entities. The one that was going to go in to the Argus Farm Stop, the old gas station, they did not meet a number of requirements that we had in place at that time, and they did not open. Needless to say, the Argus Farm Stop did, and I think people in the Fifth Ward are happy about that.
Well, and also the committee that their second meeting had the exact same question and invited the Ann Arbor PD and Washtenaw County Sheriff's Department to come and talk specifically about issues they've had with either facilities in Ann Arbor related to crime or other issues, and then from a countywide perspective where they at. And it was actually, wasn't a long discussion, but both police agencies were there, and the Ann Arbor Fire Department came as well to talk about any special concerns or issues they have had.
But we did have, for example, early on Main Street, there was a facility on the second level that did have a well-publicized robbery, and it was not, it was somewhat frightening during the daytime. The police actually did a fabulous job in taking care of that. But, part of the problem is, and part of the problem with this issue not coming down through the federal regulations being promulgated is the cash issue at dealing with transactions in cash and whether you can put them in a bank account. Those are all issues that are beginning to get resolved. But there are data points on this, and I think overall the police have talked about this.
If only pot were cheaper. So I want to reflect on our 45-year experience with basically decriminalizing marijuana. And I think that what we should learn from that is that the simplicity of our ordinance and removing ourselves from law enforcement on mere possession worked out fairly well. And the difficulties I had with our previous efforts to zone and regulate dispensaries is just how complicated and how much record keeping and how invasive and cumbersome it was. And so to the extent that we can keep it simpler and really not get so involved with the mechanics of marijuana business, I would appreciate greatly.
And again, that was done when the state wasn't clear, and now, at least if you look at it on the surface, they've taken all of the control of that aspect of it, and we will look at what's left. But I hear you saying that
Yes.
you're happy they're doing it, as far as the timing.
So thank you.
Councilmember Westfall.
Thank you. I heard some restrictions from the state level having to do with growing. Is that the only zoning mandate?
Yeah, that we know about. We haven't seen any others. That's the one that's specifically, yes.
Okay. Would, just by the definition of the safety compliance or testing, would that also self-limit to industrial zones or research/industrial?
I would,
Yeah, I'd have to go back and look. What we currently have defined as a research laboratory, I'm not sure exactly what the total zoning districts that's allowed in off the top of my head.
Okay.
It would be limited to that type of defined use within the ordinance, all of which districts either as permitted or special exception. I can't recite off the top of my head.
And as a neighbor of the Main Street business in question that had some trouble, actually, as I was leaving my office, I held the door for the feds and others to go up and visit them, having narrowly missed the unfortunate robbery incident a week prior. I'm hoping there's some controls when we're talking about processing or dispensary-type storefronts in terms of odor and being a good neighbor, because that was a huge issue for everybody in the building. I've heard that there might be some restrictions regarding security, which is another obvious one until that gets sorted out, but
yeah, that was a problem on Main Street, and I think the landlord eventually, whether they evicted the person or whatever, they had a problem with that.
yeah. And I guess, without getting too much into the weeds, this would not qualify as a home-based business. Is that
You have to understand
excluded
that
for limited retail?
The 2016 Act does not, the 2008 Act remains in effect, and so local grow operations still in a house are covered by the other statute and not this, and I believe that's something that we're going to look at, because there were concerns at the time about 60 plants is a lot of plants in a residential home. It's a lot of plants, and especially there were, in other cities, for example, there were people buying homes in residential neighborhoods and not living in them, but just having an operation. And obviously, that is an issue, and it would be a great issue here, and there were concerns about that.
Yeah, if we thought Airbnb is a problem. A whole nother level. And are there, just as we're thinking about this throughout the year, are there certain techniques zoning-wise, I'm thinking, that we should keep our ears open for, that other communities might be using to some degree of success, just so we have some kind of a framework to think about this as we hear about it and then discuss it?
As staff, we're certainly open to any suggestions. We've been looking at how communities have zoned and handled medical marijuana facilities under the existing legislation, and how they're going to morph, or those tools are going to evolve, and who's been successful in doing it. So we have quite a litany of other examples of communities that have dealt with it. We definitely have some suggestions going forward on how the zoning should work here. Are just kind of waiting for the ordinance committee to do its bit, so we know what we're dealing with, and then we'll be able to take that, apply our suggestions, and move those forward to the planning commission. But yes, if you see or hear of any other tools, we're certainly open to taking input from anybody on a better way of doing things.
I mean, I just from my research on banks, I know that they've used like spacing requirements and so on,
Yeah, many communities have qualified what are previously dispensaries or facilities as special land uses, which allow you to have criteria-based review. Here, that would be a special exception use. We've talked about what of the 5 types may fit with that, allowing some type of criteria-based review, also distance spacing between and from other land uses.
I don't want to infer that these are as harmful as banks. That's it, thank you.
The other thing, while there's a lot of work, and again, the interest of the city administrator right away to keep a handle on this, the work of Kristen Larkham in my office, and certainly Mr. Delacourt right away looking at where this is going. While you have a June 30th deadline, in some ways you want information, what you have to remember is the fact that the law doesn't change in some ways until until the city's ready to implement this. And so there's nothing magic, that was really the the caution in some ways from Director Edgerton is that for everybody's thinking that they have to do something by December 15th, you don't do anything by December 15th for the communities that aren't ready yet. It will, I think it's a good target to have, but we don't know, December 16th, they're going to be inundated. We don't know if they're going to be up and running. We don't know how long they're going to take to actually process a license. And so, yes, it's good to be ready if that's the direction that the city goes, but my recommendation is certainly to do it right and to spend the time that it takes to do it right, looking at this December 15th as a goal. But if things aren't ready at the state level or we don't have things ironed out, I think it's a very good target to have it earlier than that. But there's nothing magic about this because if you haven't adopted it, it's not in place.
Councilmember Ackerman.
Thanks. I just quickly wanted to speak to the laboratory zoning. Laboratories are a specific use in our zoning ordinance right now, and they're restricted to the RE and ORL districts, which are specifically designed for laboratories, and then M1, M1A, and M2.
Yeah, and as staff, what we've discussed is maybe tweaking the definition of laboratory, and then talking about whether there's any criteria that would be special to this type of material for testing.
I had a question with respect to the use of the facilities and on the revenue side. I understand that with respect to each of the facilities, each of the 5, and then the subgroups on the GROW, that there's a $5,000 cap on what the fee that we put together, but that with respect to the sales tax side, that there's also a revenue component that comes back directly
Yes.
to the municipality.
Yep.
Does that sales tax component hit on all 5 facilities, even though those that provide services and those that provide goods?
I believe that the taxes on provisioning centers, I know that is 3% of gross receipts, and then there's 25% going back where the marijuana facilities are located. So I'll have to check that as to the criterion of each of that taxation.
For my part, I'm not sure that I would include that as a determining factor, but the distinguishing revenue characteristics of the facilities would be germane to how I look at it. Councilor Lum.
Yeah, and just sort of follow on to a question that Councilor Eaton was asking about the number of dispensaries, and you said you thought that we had more than 10. I was just wondering, who tracks the medical marijuana program today? The state or the city?
The state, they don't exist as far as the state's concerned. I know that there's been some calculation in just what's going on in the building development. I think police have knowledge of these things, so I think there is you do have some sense of the numbers, yeah.
We do, because regardless of what the use and from the building standpoint or the occupancy standpoint, it's difficult for us to distinguish the legalities of the operation. That's for others to do. To date, I think you're correct, I think it's approximately 13 that have at some point or time are open and have touched with the city, either regarding a license request, which obviously, per Mr. Postma, the process changed, or some type of occupancy inspection through the building department to be open to the public. So, and those are in differing states of evaluation.
So does that mean in the city that we have then 13 registered primary caregivers in the city, or no?
No, that's.
Do we have any
those two-
idea how many of those we have?
No, we do not know that information, and it's somewhat hard to get that information. We know that statewide, there's a huge number of patients, and
I was going to ask you if we know how many registered qualifying patients we have.
no, for the city, we don't, but I think it's been reported, and we will provide some of that
Okay,
information,
that would be
because
good information to have.
I would believe that it's a significant number, and
Okay.
I think that would be the case.
Okay, thank you.
Further questions from council? Councilmember Frenzel.
Lots of citizen and council-related questions to safety, especially around the incident that we had a few years ago. Can you speak to points that the state has brought up about how the new licensing would impact the safety and around the regulation around safety of these different uses?
No, I know some of the money is going into, obviously, FTEs for background checks and pre-licensure issues, certainly enforcement, and then dealing with administrative complaints and other things. But again, on that issue, again, there's a lot in theory, but how it's going to play out and whether there's going to be any additional restrictions, I really don't know. The timing of the last issue was frankly some time ago, and I think the police can give more updated information on that.
To that point, what other information are we waiting for the state to determine?
For the state, I think
That's critical and germane to our discussion.
tonight, I think practically they're trying to weigh again who moves first. You know, if somebody applies for the state business license and we haven't done anything, then what happens? If we decide that we want to permit, do we have permitting contingent upon a state, on the state issuing a license, or do they get the license first and then come back to us and we say, you can't come back to us for a permit until you have the state license in hand? That's something that frankly the director understood that was certainly going to be an issue. And so the fact that I can't fully answer that basic question for you is one that we will be pressing the state on. But I think that in theory, you can do things contingent on things all the time in the law and permitting, and so I don't see that as a huge conceptual obstacle. We have time to think about it. We have some good minds to think about it, and Mr. Delacourt is thinking about it now. So,
A couple more. Question that came to mind while a couple of the council members had questions. The businesses are currently working cash only, is that correct?
it's my understanding.
Yeah, I don't know their operational model.
Through that being federally illegal, in what way does that impact our ability to collect fees from them in any way?
It's an excellent question, and it deals with the history of, again, in dealing with the federal government, there were letters coming out of the Justice Department over a period of time that changed. One that caught us short that we dealt with in I believe, 2012, was a memo that seemed to say that they were going to enforce this against everybody involved, and including sort of a warning to cities being involved in licensing or dealing with entities, and it was somewhat ominous tone. That switched in 2013, and so again, we need to look carefully out of the new Justice Department and what things have gone forward, but there's been a significant, almost a sea change in the nation as to this activity and the state regulatory framework. And again, for suddenly them to go back to another tone, that would be 2011 or 2012, that would be more concerning. I don't see it going back there. That's not the tone that they have now.
I know as well, as part of the committee conversations and internally as staff, we've talked with finance about if the city does move forward with a licensing ordinance, we're going to have to work with them to understand how they're comfortable accepting fees and
Right.
what that looks like.
We actually never accepted the fees and never cashed the checks, and the people who initially applied, either that money is stored away somewhere and they'll be getting it back, or I don't know the mechanism, but the fact is, I don't think, because of that, I don't think we did anything with any money that was taken in under the prior licensing scheme.
It's a good point. I did receive copies of the original applications, and so there was an application process that happened, just we did not process them. I think that's a good thing for us to remember at this point. And my last question, Mr. Postma, you brought up that at the state level or at the national level, perhaps this is perhaps a stepping stone towards full legalization. And I'd like your thoughts on how this sets us forward in that direction, or is a separate space for that conversation, or your thoughts on that matter?
Now that I'm up here, you're asking all sorts of non-legal questions that I am always suspect to answer. But I think that it's a fair question in one sense because our office has spent a very significant amount of time in looking at this in 2004. Again, this was done 4 years before the state, and the fact is that often local communities are at the forefront of change. And again, I'm not saying whether that's right or wrong in this case. The state has made a policy decision now on medical marijuana. The people did vote on that in 2008. And so that certainly is the law. They made a correction in 2016 to cover facilities. And why I think it's a change in that direction is because the same things that I'm seeing, the statistics at the beginning, well, now we're at 28 entities. Again, when we started in 2008, Michigan was 13, so that's 15. That's 15 additional states in an 8-year period. And again, you're going now to 8 states for full legalization. And so I think that when there's a mechanism in place that can assess how a business can operate in a community, how a police can deal with it, how a city can deal with it, they have more data points so that cities then become more responsive and states deal with it in a way that they think is best. So that's really what I'm judging it. I've spent a lot of time reading it. I've read the articles. I've had many free interns from the University of Michigan and the law school provide me every data point as it shifts, by month practically, and because I think it's important to understand that. So that's a projection, and I'm just looking at it. The federal government, though, and I included a site. Again, I'm looking at the long haul right now. They've made a clear distinction between medical marijuana and recreational, and this Attorney General has a very different view of recreational marijuana as opposed to the prior two Attorney Generals, and their view and especially their concern about incarceration for people engaged, and that I would submit is a legitimate concern for this body and for policing in general to look at it. So again, I'm not weighing in on the policy issue. I'm saying that there are very real legal issues and competing interests about when you legalize something and how a city moves forward. So I'm just looking at data points, and I'm seeing that state legalization growing.
And I can say, staff, we've had that conversation on the non-legal side extensively. We recognize and are developing a licensing or permitting ordinance and zoning ordinances that are centered and based on medical marijuana within the community. That's what's legal now. But we would be crazy not to be looking with an eye towards the future. And as a staff standpoint, hoping to develop something that if it is legalized at some point, that we don't have to tear it all back down and start over again. It may need to be tweaked, but if it becomes the framework for the state someday to legalize it recreational, if this is the same framework, 5 license types, we're hoping what we put together from a licensing and a zoning standpoint doesn't have to be torn back apart and can be adjusted to accept that new reality. So,
I appreciate your thinking ahead on that one and taking non-black and white questions.
Well, if I start my research at 2900 BC, I'm certainly going to go forward at least a decade or two, council member.
Further questions? Thank you both very much. This was very helpful to us and I'm sure the public. Thank you. We now come to public comment general time. Public comment general time is an opportunity for members of the public to speak to council and the community about matters of municipal interest. To speak at public comment general time, you need not have signed up in advance. Speakers will have 3 minutes in which to speak, so please pay close attention to the time clock. As a matter of courtesy, we may have only one person speaking at a time. And finally, if you require assistance in speaking before council, we'd be delighted to provide it to you. Is there anyone who today would like to speak at public comment? So please just come on up.
Good evening, council. My name is Matthew Berkey. Everybody can hear me clearly, right? I don't think I even need this. I just wanted to give one specific response to a question about what would the effect be on Ann Arbor residents if we didn't allow growing and processing in the city? And I couldn't see who it was from behind this lectern who asked that question, but it was coming from this direction. So currently what happens is dispensaries have close relationships with local growers who provide them with the strains of medical cannabis and the quality that their patients ask for. So there's a very close relationship there. If you allowed dispensaries here to distribute to medical marijuana patients in the city, but disallowed local growers, what it would mean under the upcoming regulatory structure is that dispensaries would then have to pay couriers, the legal couriers, who would be the only ones legally allowed to transport the cannabis, to drive to another city that allows growers and bring that cannabis back to the local dispensaries. So we can see what that would do immediately. Immediately, it would raise the cost of the medical cannabis in the Ann Arbor dispensaries, which Councilman Eaton already observed is quite high. Okay, so it would raise prices for Ann Arbor residents. It would also reduce availability, because the Ann Arbor dispensaries would be second or third in line to the dispensaries that are where the local growers are. So it would raise prices, it would limit availability of different strains, and it would also then impact the profit. Now we're going into the business side of it, but profits for local dispensaries, because they're going to be paying the couriers more to drive out somewhere and purchase it, and also they'll be losing customers. For the low-income customers in Ann Arbor, they'll just drive to Ypsilanti or they'll drive to Belleville and get it at cheaper prices. So you sort of have to have, in my view, you sort of have to have growers here and processors as well, because there's a very close relationship. And that's how it would affect people in Ann Arbor. Thank you.
Thank you. Is there anyone else who'd like to speak at public comment? Seeing no one, public comment is closed. May I have a motion to adjourn, please? Moved by Councilmember Smith, seconded by Councilmember Warpachowski. Discussion? All in favor? Opposed? We are adjourned.